Hi, I'm Deandra Grant. Welcome back. If you've been watching our playlist, this is one of our videos where we're going to do a little bit of a hodgepodge. I'm here with Douglas Huff, who's president of Dallas Criminal Defense Bar. We're just going to run through a couple of topics that have not been covered in previous videos. One of them is occupational licenses. One of them is how to visit your client in jail. And the third one is going to be trial appearances. So let's start with occupational license. Misdemeanor occupational license, DWI case. How do you get one?
So a misdemeanor DWI occupational license is all just filed, and 90% of the time in Dallas County, you're going to have to appear on an occupational driver's license. You're going to file it. There's multiple steps, which needs that
Its own video.
its own video, but that filing will occur, and then your occupational license will be signed off on. The if it is a felony occupational driver's license, and you're still going to file everything, but now you're going to actually have a prove up hearing.
Yeah.
That's going to be in front of the magistrate court associated with your originating court. So even though you
So it's going
haven't,
to be on floor 6 or floor 7 in
yes,
the magistrate court.
and they hear all felony occupational driver's licenses. Well, you're going to have this felony occupational driver's license. You will bring your client must be present for this, and you have to have all of your paperwork in order. And there's again,
A lot.
putting together an occupational driver's license is a chapter in a book. But once you have all of that, you'll go in front of the magistrate judge in felony court, and you'll prove up your motion. It's very you're really kind of just reading from your own writing. You're going to ask your client specific questions and kind of run through that, and then the judge will grant it. And depending on what type of occupational driver's license as well. So if it's a felony, it's very likely it's going to be an interlock driver's license.
It will be.
Yeah.
But they've already got an interlock as a requirement of bond, so your client should already have an interlock. So Dallas getting an occupational license is a lot easier than some other counties. Pretty, it's pretty streamlined. So it's a little trickier in felony court, but not impossible when we get them all the time. So, and if only there were a book that had an entire chapter on this. Gosh, I can't.
Yeah,
Can't
speaking
imagine.
of chapters,
Speaking of books, I might have written one that has a chapter on this and has all the forms. All right, now I'm moving on to a completely different topic. How do you visit somebody in jail?
okay, so you've got two different options really to visit someone in jail in Dallas County. You can go over to Lou Sterrett. Go to you can look them up on jail lookup, find out what tower they're in, because there's a west tower,
North
there's a
Tower,
north tower, and then there's Kay's tower.
Case Tower.
Okay, and Kay's tower comes in through a different entrance. But once you go into whatever tower that you're going into, you're going to have to provide them with your identification and your bar card. So
Have your bar card. You can't get in without it.
they will not let you in without that.
Who can you take with you?
You can't take anybody with you without special permission.
Okay.
Okay. So now, if you can bring another attorney because they have a bar card. So if you have an associate,
What if you need an interpreter?
then you need to get permission from the jail to have your interpreter come in.
Okay.
And it's not a hard process. They'll sign off on this paperwork. You're just requesting for them to have it, for you to be able to have an interpreter. I will usually get them to sign off on it for any time we need an interpreter, not to just be for that visit, but for any visits on this particular client.
Okay.
Because that way, if you have to go back more than one time, you're not having to go and get a new sheet. You just put that in your file, and you're able to present that whenever you go in.
What can you take in the jail with you?
Normal visitation for everybody else, there's a lot of restrictions. For an attorney, there's very little. Every so often, they get a wild hair and they try to prevent attorneys from bringing in laptops or something like that.
But then we'll raise some hell, and they usually say that wasn't the rule. This person's new, and they didn't know
Exactly.
what the rules
Well, because
we have to show our clients stuff, paper like documents and things like that. So you
Yeah.
need a laptop.
Whether there's videos and
Oh yeah, you might want to show them some videos.
all of this kind of thing. So now, when you go into the jail, whether it is in any one of the towers, they have visitation. And they have attorney visitation rooms,
Okay.
and then they'll have like an open air area where they have windows and stools for normal visitation for people like family and friends and stuff like that. Except for Kay's Tower. Kay's Tower, every one of those rooms is separated. It's its own little special separated.
Oh, I've been
room.
there. It's very lovely.
So You're going to be behind glass. They will, when you first walk into the floor that your client, when you first get to the jail, you'll provide them with your information. There's a little slip that you have to fill out,
Yep.
and then you're going to provide the sheriff your identification and your bar card and the slip. They will give back to you your bar card and the slip, as well as a visitor pass. They will keep your identification. You don't get the identification back until you get your bar, until you
Come back at
come
the
back
end. Hmm.
to at the end. So they'll keep your ID. You'll go to whatever floor you need to go to. When you get to that floor, there's going to be a window that you
Like a
can,
guard area,
yeah,
like a window
a
thing.
guard window that you have to get their attention and let them know that you're here for an attorney visit. If it's in west or north, they're going to refer you to the attorney visitation booth, because remember, everything else is open air. If you're in K's, they'll just tell you what booth to go to,
Hmm.
and then they're going to go get your client. Oh, as a side note, they'll ask you if your client needs to sign anything, because there's a little window that they will unlock for you to be able to pass documents back and forth. And if you need them to be able to sign stuff, then you need to let them know that. Otherwise, you're talking through glass through a phone.
Through a phone. All right. There's an alternative.
There is an
What's the
alternative.
alternative?
So the alternative is a video conference.
Okay.
Okay. Um, they've got different places around the courthouse that you can do video conferencing. There used to be one down on the original um, defense workroom.
Yeah,
Uh,
down on the first floor before you got into the lawyer lounge, there were all these video visitations, and then inside the lawyer's lounge there was video visitation. But we moved the lounge up to the 8th floor, and there is still video visitation in there, quite a
yeah,
bit actually.
yeah. There's quite a bit set up for video visitation on the 8th floor in the lawyers lounge. If you're a public defender, then you know you have access to video visitation in the public defender's office. But otherwise, video is that way. Um, they experimented with remote video. It has
Yeah,
not gone well. So these are
yeah, they were
really,
trying to give defense attorneys a login basically where you could do video conferencing with your client on your laptop or your desktop at your office. And there was a test run with some attorneys, and then it just doesn't seem to have
yeah, kind of fizzled.
fizzled. So we don't really know why. It seems if you could do it on this system, you should be able to do it on your computer. But this is Dallas, so they got to do their own thing.
Well, it's very specialized software.
Yes.
Okay. And, one of the things that whether people, some people are very for doing video conferences with their client and for ease of use. Others will feel that they would want to do it face to face, because anything through that video, well, we've seen across the nation that sometimes those videos are recorded even though they're not supposed to be, because of the attorney-client privilege.
Right. Well, let's say you're going to do a video conference. You're in the lawyer's lounge on the 8th floor. Um, how do you do it? Like, what are the steps?
So what you're going to do is, there's a phone there and there's a video screen. And what you're going to do is you're going to contact the jail. Okay. And the floor, there's numbers so you can call them on what floor that your client is on, and let them know that you're set up for a video. And then they'll tell you, okay, you access to this video booth. And then now you're looking at a video booth while they bring the client in. And then the client is going in the jail, a room that's very similar to the attorney booth, except instead the only thing that's in there is a video recorder that they're looking at, and so they're talking to you through that. But it's a phone call to the jail. They set it up. They have your client
Yeah, because
on
they
it.
have to know which room to put your client in. And you just all be coordinated so that when they turn on the camera, your client's there, not somebody else's client. So you
Right.
basically have to coordinate with the jail. It's usually pretty fast, unless there's
Yeah.
some problem. Your client's in medical for some reason or something like that would be the reason they wouldn't be able to bring them over. But normally,
Yeah.
it's a pretty easy system in Dallas.
Yeah, it's not difficult. In fact, I would even argue
What
that.
percentage do you do of video conferencing versus jail visit in person?
I'm sorry.
What percentage do you think you do more in person or more video?
Personally, I don't do video at all.
Yeah, I can't remember the last time I actually heard you say that you had done a video conference with a client. You always go to jail.
I always go to the jail. It's a personal preference. I think that it builds the credibility for the attorney to be face to face with their client. Um,
It's more humanizing.
yeah,
I will say that I do think that if you just had a court date, your client's in jail, they weren't participating in the court date, you were just making an announcement, and you're just trying to pass information to them.
yeah,
Hey, I just talked to the prosecutor. They're contacting that witness that we wanted them to contact, and they're going to get an answer back to me in the next 2 weeks, and then I'll come see you at the jail with the answer. If it's just like a little quick thing you want to tell them, I don't have a problem. But I also am of the same opinion that I feel like if you're very in-depth conversations, like whether you're going to go to trial or not, or what does the evidence really show, or you're getting in an argument with them about it, you need to go do that in person. That shouldn't be on a
right.
video. That's just our, but you, but that's just something to think about.
Yeah, my personal preference is my clients that are sitting in jail are the ones that are charged.
And they're sitting in jail.
Yeah, they're there for something a little bit more serious.
Hmm.
We're not generally sitting in jail on a misdemeanor case.
Hmm.
And so because they're facing penitentiary time, because it's going to be a felony, um, uh, having them see their attorney come in actually means a lot to them.
I agree. I agree. I don't do court appointments anymore, but I did for a very long time, and I had a rule that I sent a letter to the jail if I hadn't seen them every 2 weeks. Just, hey, how's it going? Just checking in. Just want to let you know there's not really been a change the last time we talked. Just so they're getting mail from me and they know that, it hasn't been a month and a half with no word from me. And so that was just my something that you may want to consider if you've got people in jail is just stay in contact with them by some means because they're sitting in jail. They have no idea what's going on. It's a very dehumanizing process. So just a thought. A completely different topic so we can wrap this up. Trial settings. I'll start with misdemeanor. Dallas does not do what other counties do. Like if you go to Denton, you have trial announcement the week before and you find out the lineup for the following week and you're told you're either going or not going. We had it one today in Denton where we have trials going next week, but they're not going because we had trial announcement and they were going on an older case. Dallas is a cattle call. So you're set for trial Monday. You show up Monday. You could be the only case on the docket. You could be one of 10 cases on the docket. Best practice, in my experience, is get in touch with the DAs the week before and just check in with them and say, hey, what's Monday's docket looking like? Are we going to be up? You guys going on a jail case? Are you going to be ready on my case? Just have a conversation. They'll usually tell you, y'all aren't going. We've got this jail case that's going, and if that doesn't go, then we've got this case that's way older than yours. Or they'll say, we're filing a motion for continuance because we can't get the blood analyst there, or whatever it is, so that you kind of know and aren't surprised on Monday. Same felony court, a little bit more serious. What do you say?
Well,
What would
I would state that in Dallas they do pretrial hearings. Okay, they do them.
Yeah, but
They
they
just
do
not
them.
affect.
They're
They're
not
not
lining up the trial though. They'll do
right.
a pretrial hearing that's like 3 weeks before the trial date, so you have no idea what's going to happen
Yeah,
on
as you
on.
know, you're turning in, you're going over any kind of pretrial motions or anything like that. You're set for trial, but the reality is in Dallas, you don't you're not 100% you're going to trial until they bring in a jury and you start for
Which
die.
is very different from calling. If you practice in calling, you're going to trial and calling. In Denton, you're the only trial. And there's no plea bargaining. Once you get set as that trial and they pick you as the trial, that's it. Your chance to plead out is over. Dallas, like I said, you could be one of many trials, or you could be the only trial. You have no idea unless you contact the DA and say, let's talk about this trial that's set Monday. And a lot of times, if they're not ready and you don't have an objection to moving it, you may reset the trial and save your client a trip down to the courthouse but the week before because everybody knows this case isn't
Yeah,
going. So it's a little bit different. I won't say loose, but it's not quite like it is in other counties when it comes to misdemeanor trial settings. Now, felony trial settings, it could be more cases set for trial in that particular court on a Monday, but you generally have a better feel if you're going, I would say, in felony court.
absolutely. The felony courts, once the case is set for trial, they're kind of expecting you to go to trial,
Yeah.
and they will.
They
You'll
won't set 15 trials. They
now
might, but there might be three or four.
Yeah, there may be, but they're also more likely to bring in another judge if they've got two trials that go at the same time.
And that can happen in misdemeanor court too. You're set, and Judge Hayes, for example, she will do that. She's got a bunch of cases set for trial. She's going to be there. She knows she's only trying one. She might see if you can get a visiting judge to hear a spillover case because we're the spillover case many times.
Yeah.
So Yeah, I mean, judges, they're like really trying to move their docket. And then same in felony court. They've got an ag rob, they got a sexual assault. They might go on the ag rob and bring in a judge to hear the sexual assault. So staying in touch with the DA. The DAs, I would feel in Dallas more so than maybe some other places, they'll tell you. They'll
Yeah.
be like, this case is probably going, or this case is probably not going because we have a conflict. Always remember whether it's misdemeanor or felony, and this is in every county. If someone's in jail and is on the trial docket, they're going to trump your probation case. I mean, your person that's on bond case, they're going to get trumped. But if a jail person pleads out on the day of trial, which we all know sometimes happens, then the bond clients are going to be up, and then it's usually in how old the case is. So if the DA says we're almost 100% going on this jail case, but you're the one right behind it, I'd be ready
Yeah.
because jail clients often fold on the day of trial when they find out it's really going to happen. And so then you would be up. And, the judges are expecting you to go to trial. So if you're set for trial, be ready.
Well, and there's going to be a pretrial hearing as well in a felony court, but very similar to the misdemeanor. You check in with the district attorney the week before the actual trial
Yeah.
for sure.
Because the
So that
pretrial hearing is what it's not,
sometimes it's
it,
3 weeks or a month
or a
beforehand.
month before the trial date. So in calling, you know, or in Denton, for example, you're set for trial next Monday in Denton. Your pretrial date's going to be like the Tuesday before. In Collin, it's the Thursday before the trial. So the week before whether it's happening. In Dallas, it isn't like that.
Yeah.
So you do need to be keeping up with finding out what's going on in that court and whether you think your case is going to go. Not just because whether you're getting ready or not, because you don't want your client to come down there thinking the case is going to trial and it's not. It's very disheartening for them. They have to get themselves emotionally ready for what they're fixing to have to go through. For us, a lot of times it's a little bit another day in the office, but for a person who's never been through this before to show up thinking they're having a trial, they're all dressed up, they bring all their family, and then it doesn't go, is not psychologically good for them. So if you need to find out in advance if you think it's going to get reset.
And I would state too that when you're talking about felony trials, usually there's a lot more witnesses and moving parts, right?
Mm-hmm.
And so the state is going to know whether or not they're moving forward with your trial or not because they're herding cats, right? They're trying to make sure that the officers are present and
Right.
that the witnesses are there and the 911, whatever they need to do to try to prove their case. And so they can't wait to the day of trial to have somebody to be reaching out to 7 to 10 different witnesses sometimes.
Right.
In most misdemeanor cases, often is the case, you're talking about 1 or 2 witnesses. And
Yeah.
a DWI, you might have an
Three.
extra
It might
3.
be three.
But otherwise, these are people that they're and often is the case too. That's all government employees, so they can route them. Where they're as opposed to bringing in a bunch of civilian witnesses that occur a lot in felony cases. I think that's one of the reasons why you will be a little bit more wishy-washy on whether or not a case is going to trial for real in a misdemeanor court, where when the state has lined everything up, the courts have started to clear the docket. You'll
In a
know,
felony court,
yeah,
yeah.
in felony court, you're going to trial if you're set.
Mhm.
With unless someone's filing a continuance, and you can't be doing that the day of, not like you can in misdemeanor.
Right, right. And you don't want to be doing that. And the only exception would be if you have some critical witness that is sick
Yeah,
or something else happened. If you have an expert that you're calling, and this goes for misdemeanor or felony, you ought to know well in advance if there's a conflict. If they're also testifying in another court the same week they're supposed to be testifying for you, it's the same as a state. You should know this well in advance and let the court know, hopefully at pretrial, if you think there's going to be a conflict. But the best thing for you and your reputation as an attorney is to always be ready.
yeah.
Always announce ready. The more you announce ready, the more those judges like you because they're always ready. These are my favorite lawyers. So, well, we hope this series has been helpful to you. If you haven't watched any of the other videos, please do so. We try to cover as many topics as we can about practice in Dallas County. If we didn't cover a topic that you think we should, or you think we should shoot a video with more detail on a particular thing like pretrial diversion programs or mental health or things like that, shoot us an email. Our email is in the comments and we will shoot some more videos.